the case in the Supreme Court, so obviously got to the elevated heights of the UK's highest court, so obviously I feel very important, is a case called Rakusen and Jepsen. Now, ironically, it's actually about a relatively small amount of money in these things. It's about £20,000 on what's called a rent repayment order, where a tenant is in a property that isn't properly licensed. In the case, it was a house of multiple occupation, should have had a license, didn't have a license, and they had sought a rent repayment order. Now, what makes it interesting is they had not sought the rent repayment order against their landlord, because this property is a rent-to-rent. So the landlord has rented it to a company in this case, which I think was called KPIG.
Kensington's
Property Investment Group,
yeah.
KPIG. I thought it sounded better as KPIG.
Yeah.
And KPIG had then sublet the property on
with the landlord's consent.
With the landlord's consent,
yeah.
absolutely, to the occupiers. They hadn't got licenses and so on, and when it came to the crunch, KPIG somewhat disappeared. They folded up their tent.
Which is common in the rent-to-rent world.
Absolutely, yeah. Rent-to-renters obviously are well known for. I mean, there are good rent-to-renters out there, but there are a fairly substantial number of not so good ones.
Yeah.
And they folded up their tent, disappeared, and the tenants therefore pursued a rent repayment order directly against the landlord. Or the superior landlord, so not their own landlord, but the landlord.
But they had no relationship.
They had no direct contractual relationship with, and the reason this became possible is that the rent repayment order regime was altered from the original Housing Act 2004 wording in the Housing and Planning Act 2016, and it wasn't done terribly well. To be fair, the focus of the Housing and Planning Act 2016 was very much on the planning side of it than the housing side of it. And that was what was debated most extensively in Parliament, because it was meant to involve liberalisation of planning laws, which strangely never quite happened, which is why we still don't have enough houses. So there was less housing and less planning. But this stuff all went through, and the wording became a bit murky in the way it was worded, and it talked about seeking a rent repayment order against a landlord, and it was possible. Or at least it was certainly argued before the Supreme Court that it was possible to read that as meaning that you could seek a rent repayment order against any landlord in a sense. And of course that was one of the weaknesses.
Rather than the relevant landlord.
Yeah, rather than your specific landlord. But of course not any landlord, but obviously a landlord who was connected with that property. Now this was of course one of the weaknesses, because of course for the tenants they're saying you can seek a rent repayment order against a landlord. And the Supreme Court goes, well, just hang on a minute. You don't mean surely any landlord in the entire... You can't just go and pick a landlord down the street and say, give us some money.
Yeah.
It has to be a landlord of this property. So that obviously was a bit of a weakness in the argument. This kind of stuff, I know, sounds to many people just ridiculous. But the reality is this happens quite a lot. Parliament tries to write legislation in English. English is not always a perfect language, as we find every day ourselves. But the courts have to try to understand what Parliament meant by a piece of legislation, and sometimes that's quite easy. Parliament writes it really well, or there are very clear speeches by ministers in Parliament, and the House has an extensive discussion. This kind of bill's much harder because, in fact, the housing stuff isn't discussed much in Parliament. There's not a lot of statements about what was meant, and so all the government said is that they wanted to make it easier to obtain rent repayment orders, and they wanted to rub out rogue landlords. Now obviously there's a question about who you consider to be roguish in this scenario, but there was certainly a challenge potentially as to what they meant. And the other argument, and then one made most strongly by the other intervener in the case, so two parties intervened. It wasn't their case, but they then got involved in the case to say, well, you need to understand, Supreme Court, there are wider things here. So safer renting's main point is actually in the very murky underworld of the private rent sector. There are an increasing number of landlords who just set up a company to then sublet the properties in HMO to insulate themselves from rent repayment orders, so that they can just fold up the company, because they know that, I mean, the argument for safe renting is they know they're never going to get prosecuted, because all these people could, of course, be prosecuted or have civil penalties. They know that's unlikely because local authorities don't get involved. So rent repayment orders are a control against these people. But if they set up a company between themselves, they can just fold up that tent, throw it away, and say, well, you can't touch me. The NRLA, who I acted for, also intervened. So I want to say it wasn't my case.
Yeah, of course.
I wasn't acting for Rakusen or Jepsen. I was acting for the NRLA, who also intervened to make points, for the wider landlord community. And our position, to some extent, was, well, you shouldn't try and widen the scope of the law beyond what Parliament very clearly meant. And if Parliament wants to widen the scope, then that's for Parliament to do. It shouldn't be something the Supreme Court.
And the final decision was obviously it was dismissed, and
and the argument that we made was quite strongly accepted. The Supreme Court said, well, the wording is not great, but in our view, it's sufficiently clear to say you can only go after your immediate landlord. We're not prepared to adopt a tortured meaning of the legislation to satisfy a clear. I mean, I don't think we can all agree that there is a decent moral case at least. But we're not prepared to adopt a torture meaning of that. It has to be for Parliament to do it. And I think this is one of the things, as a lawyer, obviously, I find really interesting about it, in that different Supreme Courts from the past would probably have taken a different reading of that legislation. So people often, and even lawyers as well, most lawyers don't deal with the Supreme Court very often.
Yeah, of course.
Those of us who are lucky enough to actually go there and deal with these cases follow it and can see that it's changed over time. And it's quite possible this case had happened with a different Supreme Court from 4 or 5 years ago, it would have gone the other way.